today's Legal Minute with the Law Office of Cooley, Shrair in Springfield. We're joined by attorney Susan Mielnikowski. We're talking about wills and trusts, but specifically challenging or contesting a will. How can someone do it? Why would they do it?
Okay, the how is where we'll start mechanically. If somebody passes away, the person in possession of the will presents it to the probate court for allowance. There is a moment in time where the court orders notice of that will. Heirs at law, people named in the will, it'll get published in the newspaper. There will be an opportunity where everybody knows that the will has been presented for allowance. That's the moment when anybody who disagrees with the will can go ahead and file a notice of appearance with the court that says, I object, followed by a very specific reason for their objections. That affidavit of objections has to support why they're coming forward to contest the will.
So what kinds of people who can contest a will? Because it can't be anybody.
It can't be anybody, can't be a stranger. It's got to be somebody who is an heir at law, which think children, grandchildren, a spouse, or somebody who was named in a prior will who has a less beneficial provision in the current will. So if you've been written out or reduced, then you can come forward and say you disagree and you think that there's reason to contest.
Oh, so if you think you've been compromised or you're not named in the will but you feel like you should have, then you can get into it and start doing it.
Correct.
Perfect. What facts, though, allow the wills to be overturned? Like, at what point will a judge say, well, you know what, you're right?
You can't just show up because you disagree with it or don't like it. You have to have reason to say this is wrong. And the burden of proof is on the person coming forward to contest it to say either it was a forged will, the person did it under undue influence, the person didn't have the competency to sign it at the time they signed it, the person didn't understand what they were signing. There's various legal criteria that you'll have to meet and you'll bear the burden of proof. But if you have a concern or a question, an attorney can go ahead and assess that for you and look at it and see if you have a reason to come forward.
So if you're thinking about contesting a will, or if you don't have one for yourself, you can write one up with your help and all the folks at Cooley Shrair.
That's right, and we'll make sure it's not contested because we'll do all the things we need to do to make sure.
You'll do the job right so that no one else can come out of the woodwork and try to grab everybody. Susan, it's always a pleasure having you here. That's your Legal Minute, and for more information, just call 413-781-0750 or visit CooleyShrair.com.